everybody. Thank you for joining us again on another episode of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, and yes, I know I said I wasn't going to be here last week, but plans changed, and so I'm here alongside my buddy, JV. Julio, what's going on, my friend?
Hey, you know, anytime James Harden does what he does, disrespect or not, Houston strong.
That was a wicked crossover last night.
It's a wicked cross. I'll tell you, it reminded me a lot of myself. Just saying.
What, in the Fat Guys basketball league you playing? What?
Oh, man. You know what was also
There's
crazy?
actually a league named that. I got it emailed to me today.
The
Fat Guys basketball league.
Like, hey.
Nah, I think it's just to get all of those who thought we were superstars in high school back playing again.
Hey, speaking of black people, how crazy was Judge McSpadden?
Oh, my God. We definitely need to talk about that.
I mean... Did you hear about that?
Great
Y'all
topic.
know about that.
Great
You know
topic
about that?
I did hear about it.
Well, we got a great show, ladies and gentlemen. We're going to talk about that and a lot of other things. I've got some personal issues that I want to discuss that happened to me this week that I want to bring up and get our guest opinion on that. And if you've got opinions on it as well, we're going to open up the phone lines about halfway through the show. 713-807-1794 will be the number. You can also tweet me at HCCLA TV _TV. Right here on Twitter. So let me introduce our guest tonight. Right here to my left, one of the candidates for the 185th, one of the Democratic candidates, and the primary is next week, ladies and gentlemen. So Brennen Dunn. Brennen, welcome to the program.
Thanks for having me here.
Absolutely. We had your opponent last week, Jason Long, and so now we have you this week, and we have mirroring courts this week.
We do.
Our second guest, Mike Renfro. You are the other Democratic candidate running for County Criminal Court at Law number 13 here in Harris County. And
That's correct.
Your opponent, Raul Rodriguez, on last week. So
yes.
We appreciate you joining us this week as well.
Thank you for having me.
It's kind of cool to hear from consecutive candidates running for the same bench when we got the primary next week. I think it allows everybody to hear the different perspectives of the candidates running, and we've had a good early voting turnout so far. Mm-hmm. I think between the two parties, 80,000 people have almost early voted.
Yeah, I think it's for the Democrats, they're like 300% over what they were for the presidential election.
It's crazy. There's so many issues in this election, I feel like, on a local criminal level. We constantly harp on this program about the bail bond lawsuit and everything. I know that's on the forefront of everybody's mind. And I want to bring it up to start this program because I actually had my first experience this week, and I know I called you about it. And it's been a nightmare. I'm going to be honest. It's been a freaking nightmare to deal with. Because what we've been told to do is not what apparently they want you to do at all. And I know, what was it? A few months ago, either right before the hurricane, we had Kelvin Banks on the program.
Right.
And he kind of outlined the way he thought things were going to work. And I kind of want to get him back on the program and get you guys' perspective on this as well, because we've been told that if you have a 2B warrant, meaning that they haven't set any kind of bond yet, and basically you can do a self-surrender, that your client's supposed to go down and interview with pretrial services, and they got to go through that process. Well, I sent a client down there on that very same issue this week, and he was turned away not once but twice by pretrial services, saying that no, what you have to do is go approach the judge with your lawyer to get a bond set. Well, if we have to be interviewed by pretrial services before we can go before a judge, and we're self-submitting ourselves to you guys for the interview, why do we have to come down to the courthouse to do it? Can any of y'all explain that concept to me?
Well, the idea is that we used to have something in Harris County called a walkthrough, or in some counties called an in and out, where if an individual had a warrant, they could get a bond established and then go in and out, or get a walkthrough, which is the bond set. They can post a bond, they don't have to go into jail, or they can go in and out and call it a day and then have a court date. when, post Harvey or all these kind of post lawsuit changes happened, we were supposed to be able to go to pretrial services and have an evaluation, like they said that we were supposed to be able to do. Once the evaluation has happened, a recommendation would be provided for some sort of bond. Mm-hmm. But apparently, that's not the case.
No.
Well, I think that what you see here is government at its finest, where the one hand doesn't know what the other hand is doing. And I mean,
wait, I sense some sarcasm coming from you. I just want to be sure.
Just a teach.
To be sure.
But no, I mean, you have to understand that this is a whole new process because judges haven't been held accountable for this bond reform up until now. And I think when you have those kind of issues that you ran into, it's probably because the judges haven't made it clear to pretrial services, hey, this is what needs to happen. Because if I can guarantee you, if they went down and told them X, Y, and Z needs to happen, then X, Y, and Z would happen. But there hasn't been that communication. And I think part of that problem is because you still have so many judges that are fighting back against the bail reform. I think that there's only two of them that have come forward up until this point, Judge Fields and Judge Jordan.
Right.
And Judge Jordan has been there from day one saying, we need to change it. And Judge Fields, kind of just got on the bandwagon of the reform. But when only 2 of the 16 county court judges are actually fighting for the appropriate type of bonds that should be set, then you're going to have this kind of rigmarole going on where one side is saying to do one thing and the other side saying, no, go back to them. It's just this ping pong back and forth because they don't want to deal with the real issue.
Well, you're running for a felony district court judge. What's your opinion on PR bonds? Man,
look, I really think that we've gotten away from the heart of what the Constitution set out for bail. I mean, it says constitutionally it's supposed to be set for the sole purpose of making sure someone comes to court for trial and hearing proceedings. It's not supposed to be punitive. And I think that that's where we are right now with punitive bail bonds being set. And I like to call it a debtor's prison because you have people that are having to basically succumb to the court system and give away the house and the baby and everything else just to go home, just to go back to work. They can't feed their families. You set this bond amount at $100,000. This family maybe makes $30,000, $40,000 a year. How are they supposed to afford that? They haven't been convicted of a crime, and yet they're sitting in jail as if they had been.
Before we get any further, introduce yourself to the viewers, and Mr. Renfro, if you could follow up after Mr. Dunn.
Absolutely. My name is Brennen Dunn, and I'm running for judge in the 185th Criminal District Court here in Harris County.
My name is Mike Renfro, and I'm running for County Criminal Court at Law number 13 in Harris County. And I would like to address the point that you raised initially about with the 2B warrants, because I also had that issue to come up. I had a client who had a warrant, knew that they had a warrant, and wanted to take care of it. And my mindset was the old school mindset. You go down to the courthouse and down to the jailhouse, 49 Sandra Center, and they'll process you through, and you'll be released. But I came to find out that what has to be done now is that the attorney actually has to find the judge, get a bond set, and then the client can then process the bond. But the problem that we have with the situation that it is in Harris County now, where criminal courts are having to share space with the civil courthouse, and some courts in the family law center, some are in the civil building, some are in juvenile justice center, that it's kind of hard to find judges sometimes. Yeah. So there I went on my task to try to find a judge, and it took me a while. I got it done and I got the bond set, and then my client was able to get the bond processed. I think we're just at a point where this stuff has to be ironed out, and once we get the process set, then it will be okay. But bail reform is a big issue. I was discussing it with some of my colleagues earlier, and there's some reasoning on both sides as to why you should set bonds, have pretrial release bonds and personal bonds for some defendants, and then why maybe in some cases there should be either higher bonds or no bonds set on other defendants. And you have to look at the type of case it is, and you have to look at the person's criminal history, and you have to look at, especially in assaultive type cases, how would the victim be affected by, or the alleged victim, be affected by that person being released on bond. So all these are issues that's got to be taken care of, got to be ironed out, and this bail reform thing is a big, big thing right now in Harris County as well, I'm sure, as in other parts of the state of Texas.
Yeah, I mean, the functional problem I see is if you walk into a courtroom with your client to get a bond set and there's a warrant out for their arrest and the judge sets the bond there in the courtroom with your client there, there's still the warrant out. So technically,
Adios, amigo.
the bailiff could take them into custody.
Right.
I mean, just because they show up in the court with the judge to set the bond, now they're at risk of being taken into custody rather than being able to do a walkthrough. What kind of sense does that make?
Doesn't make any. I mean, I think that, and I think that's also a technology issue that we have with the system. I mean, some of the procedures that we have are kind of outdated
Right.
for where we are technologically, and I think that that's one thing that certainly needs to be real time. You should be able to go in there, clear out that warrant immediately. If you set the bond, especially if it's a PR bond, because I mean that's an automatic go free, go home, young man. And so at some point you have to have technology match up with present day justice system reform.
Okay, so you run a courthouse, you run a courtroom, Mr. Dunn. Technology in the courtroom. What's your piece on it?
I mean, I'm all for it. I mean, we can't live in an antiquated world and try to speak progressive things. Those two don't go hand in hand. So if you're going to be progressive with your ideology, then you should probably be progressive with the technology as well.
What are you thinking about? Okay, so what types of technology, if you had a courtroom, would you implement?
Is this like my Christmas wish?
Yeah, it's Christmas wish coming in.
Unlimited budget from Harris County.
I don't even know if
you're running your own court. You're running your own courtroom, man. As many of them already do. They say, and during the voir dire, this is my courtroom, and this is how I've done it.
Yeah.
This is how it is. You run your own courtroom. What's the technology looking like?
I mean, I think that on one end you've got some kind of app or something where attorneys can check in via an app process instead of having to try to call the court. You don't get the court. You're calling. No one's picking up because the court coordinator's busy doing something else. So why not do an electronic check-in process?
It's wonderful. You can check into emergency rooms nowadays. It'd be great if I was going to your courtroom in the jail, and instead of signing in, everybody knows this. We have to sign in on a piece of paper, and instead of signing on a piece of paper, we could just check in. And they can bring that inmate up, and then we can start to do business that way. That'd be brilliant. That's a great idea.
Well, thank you. Do I have your vote?
Well, hey, I live in Pearland, so I live in Pearland. Okay, so we're talking
Are
about.
you talking about attorneys checking in or defendants checking in?
Well, I mean, quite honestly, both. But I mean, the presumption was the attorneys checking in first.
Okay.
But I don't see why you couldn't have it across the board, though.
Yeah.
Late calls being made, check-ins, all of that being done electronically. And personally, I really don't think, you bring up a point about the citizens that are sitting in court. I really don't think that if an attorney isn't there to plea out a case or an attorney isn't there to have something dispositive happen with the case, I honestly don't think that defendants in a case should be required to be there every time. I mean, you're clogging up, especially now that we have this condensed courtroom setting, where you have multiple. We've combined two whole separate facilities into one. It helps out with the efficiency of getting into court. You have to remember these are citizens who still presumably have jobs to go to. Why am I taking them out when you have attorneys that may not show up for 2, 3, 4, 5 hours? You check in at 8:30, but you can't leave. You're beholden to the court simply to sit there until your attorney says, "Hey, I got your reset paperwork. Go ahead and go." Well, what did we do? Oh, well, we have to come back next week for X, Y, and Z. So I've wasted a whole day of my life, while the attorney still gets paid to do their job, but I'm not making any money. I still have to pay the attorney. I still have to pay my mortgage, all of these things. So I think we need to make sure that, again, antiquated practices simply because this is the way we've always done it.
And I think the system is moving towards that. You guys may know that they have what's called now attorney consult conferences. But they're using it with jail cases right now, where the defense attorney can go to court and consult with the DA. It's a docket call, a docket case. The case is docketed, so the files and everything are there, but the defendant is not there, of course, because he's in jail. And the way the system is set up right now, he can't be there. But I think we would probably move to something like that, where the defendant would not need to be there every time, because there, like you said, a lot of instances, nothing's being done except for the two lawyers talking, and essentially the case is being reset. So I think right now, one of the reasons why they're keeping it like that, in case there can be something worked out, maybe the case can get played out on that day. But I don't see any reason. I'm kind of like you. That would be really, really good if we could have situations where the defendant does not have to take off from job, or does not have to be so inconvenienced in being in court with the traffic situation, with the crowded courtroom situation. You know, as we know, coming into the lobby, and lobby's backed up, elevators backed up. You can't get up to the courtroom, and then when you finally do, the judge revokes the bond because you're not there on time. There's got to be a better resolution to that.
Oh, there's a better resolution coming for our redesigned criminal courthouse.
Oh my God, yes.
The lovely elevators are going to stick on the outside of the building.
On the outside?
Yeah.
Oh, really?
They're gonna like fly up?
Yeah, you didn't? Did you read about that?
I
No, I
didn't know
didn't.
about that.
Yeah, it's
I've
gonna be
been too
on
busy
the
running
outside.
around.
The plan is they're going to put elevators on a new elevator bank on the outside of the building.
Oh, that's
So we're gonna
So-
go up like
The glass elevators. And,
Yeah.
And Willy Wonka.
So go straight to the.
It feels like kind of a Chernobyl type of solution.
understand, yeah.
we have a nuclear facility, and we got a problem. We're just going to slap some stuff on the outside and cover it up.
They
You're
did
gonna
say it was
make
gonna
an ugly
include
building even
defense
uglier.
lawyers too.
Huh?
They said the elevators would be judges, state, and defense lawyers.
Oh, they're going to allow us in there?
That's what they said. At least that's what I'm gonna hold you to it, Emmett. Judge.
But wait, so
Emmett.
what happens to the judges' elevators?
Maybe they have a secret bat elevator.
Well, remember they always did.
I think that's still gonna be involved.
Yeah.
So now they have 2 points of entry.
Yeah, right.
Mr. Renfro, okay, so you're running a misdemeanor docket. We got thousands upon thousands of misdemeanors coming through. How are you going to run your docket?
Very good question. We've got to find out ways to reduce the size of the dockets. And I tell you, personally, the way I feel is that there are a lot of cases that's being processed in the system that don't need to be there. And that starts with the DA's office, that starts with law enforcement, in just trying to come up with a different way of handling that before it gets to the courtroom system. Because once it gets in there, then of course there's going to be there's a process.
But you have no power of that as a judge, whether the DA accepts a charge or not.
Well, and the DA's office and HPD are on such great terms.
Right. Well, right.
They're getting along swimmingly.
Yeah, I mean,
Well, but
I
you
mean-
know, the judges, we don't know what goes on behind closed doors.
That's true.
Hopefully, Mr. Dunn and I will find out. But they have committees, they have panels. And in those committees, in those panels, they can make recommendations, and they can maybe get law enforcement together with the Sheriff's Department, with the HPD, with the DA's office, and let's talk. Let's talk about some of these cases that's coming in, these pretext arrests, these types of cases where actually they could be handled on the outside without us having to deal with them.
But is that really the role of the judiciary to get involved in that?
I think so.
Why?
I think
mean,
so.
they're a separate branch of government. I mean, they're not supposed to be involved in the executive.
Well, you
portion. They're
asked
supposed to be the
you
check
asked
and
the
balance.
question about well, he did ask the question about docket control, about
Right.
how do we ease that problem, and we ease that problem by keeping some of the really what I would consider problematic type cases out of our system. I mean, really, guys, you talk about these less than a gram cases. You talk about they got cases now, assaultive type cases that used to not even be prosecuted, and now they're still being prosecuted, even though complainants are saying, "I don't want the case prosecuted." Right. And sometimes they blow these things up more than what they really are. I mean, there's other ways that they can be handled, and I think that the judges have to just step it up, just look the same that they're doing with this bond situation.
a number of judges calls those assault cases. They say they call them the oops cases. oops, is this, and they say, well, Judge, this is an assault family member. And the judge will reply, without naming them, they say, is this a oops case? Mm-hmm. Is this a oops case? However, those particular judges aren't not finding PC. They're not granting the magistrate order for emergency protection. So are you saying that maybe, and it's common, you know what judge is going to take what in their court. So are you saying as a principle, not as in any sort of case or how you'd rule in anything, but that, hey, look, if you're going to come with some bull kind of weak A case to your judge, that judge very well might have to revisit PC?
I am certainly saying that.
Fair enough.
I am certainly saying that because as a criminal defense attorney for nearly 40 years now, I'd represent people with those types of cases all the time. And that is my position when I go in. Do you really think that these kind of cases should be prosecuted? I mean, look, complainants even come down with them. Look, it didn't happen like that. I was just upset at the time, and I need him at home. You know, these things. Now I know from a judicial standpoint, there's other ways you got to look at it, because what a judge doesn't want to happen is that you kind of blow that case off, and then the next thing you know, now a person has serious bodily injury, maybe even death. So you gotta weigh the options, but still, like you just suggested, or you reiterated, alluded to, sometimes you got to look at, well, maybe there is no probable cause, or maybe I'm not going to order a MOEP or order no contact.
Right.
And that can maybe help resolve the case down the line.
So, Mr. Dunn, what makes you think that you can be a felony judge?
What makes me think that I can be a felony judge? Most of the criminal work that I do is on the felony level. I don't do too many misdemeanor cases, so I'm not trying to be a misdemeanor judge, because that's where my expertise lies in criminal law on the felony side. And I've practiced on the federal level doing criminal cases, in quasi-criminal cases, and I've tried everything from capital murder on down to possession of marijuana and prostitution. Matter of fact, my very first case, I was in my third year of law school when I was trying my first trial, and it was a prostitution case, going after an affirmative defense of entrapment. So the kind of stuff that you don't necessarily hear about all the times of defense. So, litigation has been the cornerstone of my practice. I don't plea out simply because I don't have time to do things. I always tell my clients, look, if you're not guilty, you're not guilty. There's no such thing as pleading out if you come to me, when I couldn't sleep at night knowing that I helped an innocent person, or a presumably innocent person, take a plea deal simply because time served sounded good. So, for me, it's always been a matter of taking to heart zealous advocacy and taking to heart litigation and being the best at what I do. So I pride myself on being the best at it. Anytime I've served as first chair in a trial, I haven't lost a case, because I believe in being the best at what I do.
Have you ever been a prosecutor or served with any district attorney's office?
I have not ever been a prosecutor. And, on the bench, we've got a lot of former prosecutors that are on the bench. And unfortunately, in my experience, and Mike can probably attest to this, most of, I'm not saying all of them, but many of the former prosecutors that are on the bench tend not to take off that prosecutorial hat. You still see them being biased in their decisions, as if they were still prosecuting cases. I've watched judges coach their young prosecutors at trial. Hey, make sure you do this while the jury's outside. You know what? Well, how can you possibly be talking to this prosecutor about what they should be doing better when you're supposed to be this unbiased, nonpartisan, fair judge sitting on the bench? So, I think the culture has to change. We've got a lot of the same that have been on the bench, and it's time for something new.
You talked about some of the judges coaching the prosecutors. Do you ever find yourself or see a situation where you are standing up for the individual accused, and when there seems to be an issue, and then you have to sua sponte raise those things. Do you think you can do that? And what's your approach, as a better question, what's your approach to the bench in judging a trial? What brings you to that, and what motivates you to that, and what are some factors that you would bring as a judge, judging people?
Mm-hmm. Well, I guess I'm not sure if I 100% understand the first part of your question, but I will say that I have never bit my tongue if I needed to express something to the judge about my client. I don't believe in being a passive attorney. You can't possibly be an advocate when you're passive. So when it comes to protecting my client, that's what I do all day long. In terms of the type of judge that needs to sit on the bench, I think it needs to be one who has empathy. And empathy comes from experience. You know, I've been that person that was walking down the street in the grassy median and had a cop stop me, and then had 4 more cop cars come and have a conversation with me because I was walking on a grassy median.
Yeah, walking while black.
Exactly. But I don't know how many judges have had that type of experience. So I don't know how many judges understand when somebody comes into their courtroom, what other socioeconomic or what other factors may play into the role of why they are there in the first place. Every person that comes into the courtroom is not a terrible person. Are there terrible people that need to be locked away? Absolutely. There are some people that simply are detriment to society. There's a great many other people that have made silly mistakes, that are on the wrong path but haven't reached the destination yet. And there are people that I always like to say there are crimes of opportunity, there are crimes of necessity, and then there are simply just bad crimes. And you have a lot of people that have crimes of necessity that aren't getting a fair shake. I had a prosecutor, I had a guy who was charged with stealing gas out of a train engine. He was a former train engineer. And so it's a felony charge for stealing this gas. And I'm talking to and so I talked to the client, I'm like, well, why'd you steal the gas? He's like, man, look, I got 5 children. When I lost my job as a train engineer, I spent the last 6 months looking for a job, couldn't find a job, and I had no more money to pay for gas to get to look for employment. And so I went to the engine. That's where I knew I could get some gas, stole some gas. And so I'm talking to this prosecutor about it, and he's like, I'll give him 5 years. I'm like, 5 years for what? He's like, well, if it was you or I, we wouldn't have done something like that. So well, let me stop you right there, because you don't know what you would do in that situation. I said, and I know if it comes to my family, I'm going to do whatever it takes to make sure that my family is taken care of and survives. So you can't sit up here and tell me, based off of your rosy lifestyle, what you would do if you're struggling. And that, to me, is the pervasive attitude and mentality of people that matriculate from that prosecutorial side over to that bench. And I think that you need people who have a little bit more empathetic view of the world, and ones who have a more realistic view of what society really has to offer to them right now. We need to change the way, provide programs for vocational and trade school. I want to partner with vocational entities and give them an opportunity to partner with us and say, look, for certain low-level nonviolent offenders, why don't we put them in trade school? Because a lot of the times it's because they don't have the resources to go to school. They don't know that school is an option, or they feel like, school's not for me. That's fine. You don't know that you can make $100,000 being a welder. You don't know that you can make $100,000 being offshore work or something like that. So why don't we present them with some different options, get them off of the streets where they think that they have to hustle, slang, and do everything else, and provide them a different alternative. Every person doesn't need to be locked up and thrown away.
Yes.
You can make $100,000 being a welder? The hell am I doing?
Yeah.
No, but in all sincerity, Mr. Dunn,
You're hosting a public access criminal justice show right now.
no,
For
but
no money at all.
what makes you think that you can judge that? What makes you think that you can determine that someone needs some skills or someone needs prison? What do you bring to the bench for that?
So you look at, in law, we all know this coined term, the totality of the circumstances, right? So instead of just looking at what the individual did, you look at their background. You look at, how they lived, what their educational status is, how much money do they make per year? If you're making $30,000 per year, or for a family of 4, then guess what? You're not making much at all. And so maybe we need to change or try to help them change the paradigm from which they came. And I think that, and you say, what makes me qualified? What makes me qualified is I put my platform points out there and I tell the constituency, this is what I want to do. If they elect me, then that's what makes me qualified.
We reached the halfway point of the program. So if you guys want to call in with any questions for our guests, 713-807-1794 is the number. We also have Twitter up at HCCLA_TV, so you can send us your questions and comments right here. I saw you wanted to get in on something.
Yeah, it's a very, very fine line. Fair and equal justice for all. That's what a judge is about, right? I mean, there are certain circumstances, and Brennen addressed that there's certain people who come into the criminal justice system and they are criminals.
Yeah.
And there is only one place for them to be, and that's in prison. I mean, that's just the sad fact of it. But we can't warehouse everybody who is charged with a crime. So I think as judge, I've got to look at, as Brennen said, the totality of the circumstances. And maybe through probation, there are programs that a person can be placed in. Maybe we need to kind of fix the probation system too, because I don't see it as always working. But yeah. I think that they're working on it, but it's not always working.
It seems like they're always trying to look for a reason to violate people. Well,
it's a trap.
And I'm not saying that to be, cliche or anything, but you hear that there's just really no sympathy sometimes if a car breaks down or they can't make a meeting or something, that there's just no sympathy for what goes on in life. And I feel like that's gotten a little better here recently. I mean, I feel like we've gotten some more empathetic, sympathetic people working in the probation office now. But I agree with you, Mike. I mean, there's some bad people. There's bad people and there's good people who make bad decisions. And unfortunately, some of those good people make bad decisions over and over and over again. But they're not truly bad people.
We have the TRAS system now, and that's one that's a work in progress. Texas Risk Assessment System. So probation, they take a person in, they evaluate them, they ask them a bunch of questions, and then on a point system, they make recommendations to the judge as to certain programs that they think that person needs to be in. Problem with that is, as I'm sure you see the same way I do, Brennen, a lot of times the recommendations just don't fit the situation. That's the problem. They want to send a kid off to WIMAC when really WIMAC is not the place for that kid to be. I mean, WIMAC can maybe be good in certain situations, but that's not always the case. Maybe this is a kid who has a job or is in school. So WIMAC is not going to fit that kid when we're trying to make that kid a productive person in society. The only thing it does is make them worse because they're around other kids who are really not trying to do anything but get back out in society so they can keep doing what they're doing. So we got to figure out ways to improve that system. And we got to also figure out ways to just make the courtroom a better place for people to be. I think one of the things that I've always talked about is that I want my courtroom to be one that is not so intimidating to people. You see bailiffs who just really treat people like they're in some boot camp or something. You got your CLOs and your clerks who do not, they're just indifferent to people. And then, of course, you got your judge who seems to always want to talk down to the lawyers, talk down to the clients. And in my courtroom, I want to have that as a better place for people to at least feel like they are, I won't say comfortable or friendly, but at least welcomed. Yeah. That they're there and they don't have to, because a lot of times I have clients that come to me when we get out of court. Ooh, that judge is so mean, or that coordinator, she just talks to me so rude, talks to my son or my friend so rude. I mean, why is it like that? And the question I have, why is it like that? And so I want my courtroom to be better than that.
Why do you suppose that people leave so many courtrooms with that feeling?
Because they have a feeling of just fear, uncomfortableness in having to come into a criminal court setting to begin with. I mean, that's what they feel. I got to go down there and deal with this judge. I got to deal with this DA. They always ask me, how's the judge? How's the DA? Well, a lot of times the judge is not even involved in the preliminary aspects of the case. Mm-hmm. So that's their problem, is that fear and that uncomfortableness, and we've got to do something to try to make that a little better for them.
You talked about the judge being involved in the preliminary aspects of a case. In a courtroom of your design, what should be the role of a judge in the preliminary aspects of a case?
Good question, but by the same token, I have to give this answer, is that a lot of times cases can be resolved between the prosecutor and the defense if they can just find a way to meet eyes on a resolution. If they can't, then maybe the judge can come in and offer up a solution to those types of issues. But it's been that way ever since I came into the system. It's still that way today. It starts with the defense attorney, it starts with the prosecutor, and then it steps up to where the judge is. So the judge is not going to be involved a lot in the preliminary parts of a case, especially that first or second setting, unless it's a case where the judge can step in and you come to the judge without an agreed recommendation, or you come to the judge because you're not able to reach a resolution and you're asking the judge, well, Judge, what would you do in that situation?
What's your opinion on things like magistrate's order for emergency protection or other bond conditions? What's your opinion, and should be the judge's involvement? So, for example, currently things like magistrate's order for emergency protections are automatic. Breathalyzers are automatic. Blow schedules in some courts are automatic. What is your opinion on the judge's role in those kind of things?
I personally have a big skepticism about the magistrate's order of emergency protection. I think it's overused. I think it's overused to a point where it becomes abusive. I really do, because a lot of times that is not even what is going on in these family situations where that's in need. I have a client now who the judge issued a no contact order, even though they are back living together.
Right.
And the complainant comes to court, Judge, I don't want a no contact order. Well, I'm going to leave one in place anyway. These are the kind of things I'm talking about. It's bogging the system down. And so the prosecutors, their role in this FCLD thing, Family Criminal Law Division, I just think they just way over the top with the way they handle those family criminal law cases. They don't try to resolve them. They want to take them, once they go into the system, they want to prosecute them to the utmost. And in some situations, they just don't need to be.
You know what I find disgusting? I know we have a phone, is when the prosecutor says, hey, this trial will be fun.
I've heard that.
It's not fun.
I've heard that.
This is, it drives me to level 11. Oh, it'll be a fun trial. This is not a fun trial. Like, the complaining witness not showing up. We got a magistrate's order for emergency protection. Complaining witness isn't on board. You know what? We could try it. It'll be fun. This is not fun. There is an individual whose life is on the line, who hangs on the balance, and every prosecutor should be ashamed of themselves who say this trial should be fun.
You know,
that is disgraceful.
You know, JV, that piggybacking off of what you're saying about that, I've seen, when I started practicing law, I think I had a totally different perspective of what happens than the actual practice that came forward. And I think that all of us have probably been disillusioned by what we actually saw. And The first time I was dealing with a client where we're talking about, they're trying to negotiate a plea deal, and they're saying, well, I'll give them 40 years. And if you have a good relationship with that prosecutor, you start off by saying, come on, man, you can do better than that. All right, we'll give them 30. Within a come on, man, you have just dropped 10 years off of a sentence.
Yep.
Not anything that's substantive, not anything that has any tangible, reasonable reality where you say, you know what, he didn't actually have this, he didn't have this, he didn't have this. Don't you think we could do a little bit better? You're absolutely right. It was, come on, man. All right, man, I'll give you 30. You haggle a little bit more. You're haggling with lives and numbers. Most of these prosecutors are not lifelong prosecutors. They come in 2, 5, maybe 10 years tops, and then they're gone to do something else. By the time you get out, whatever joviality you had in fun in throwing out a number to get a high five from one of your colleagues, that person is still in prison based off of your actions or inactions. And I was so disgusted by the cavalierness of it all, and we get desensitized by it because we're in there every day. We see it every day. All we do is, try to make sure our client gets the best deal possible. But that best deal is sometimes predicated on the whims of a DA. And that's a scary proposition right there. And I think that's something, when you talk about the disparity in sentencing for minorities and the majority counterparts, that trickles up to the bench as well, in terms of, because certainly the bench could look at a plea deal and say, this is absurd. Go back and try this again. You're giving 20 years on an assault case, that has no injury on it. You know what I'm saying? But yet and still, this person is giving a 20-year. Well, Judge, that's what they offered us. So now we have to take it. Instead of being proactive in the process. Again, passiveness should not be the term used for an attorney.
It would be something to see a judge say, that's too much time, I'm rejecting the plea. I don't think I've ever seen that.
It'd be something to say for a judge to say, all black people are tainted.
Yeah, they did say, let's get to that in a moment. Let's take our phone call. Hello, thanks for calling Reasonable Doubt. Hello.
Did we talk too long?
Maybe. Hello. Did they hang up? Or they're dialing right now. Who knows?
Yeah, well.
So
they're gone.
So, JV, was that a segue to talk about the Mike McSpadden
That worked out
situation?
There was. Okay, so look. So we've had this group of judges across the board on misdemeanors and felonies. And look, I'll be the first one to say, and you can mark me all day long, that most of the judges follow the law and have good intentions. But ideologically, there's a difference as to who deserves bond, how you're going to sentence people, how you're going to approach a case as a judge. Okay? And there seems to be a shift, or not. There seems to be a battle, at least now, that how we're approaching the justice system needs to change. How we're approaching individuals who are accused of crimes needs to change. And in the news, we have things like 30-year judges saying that particularly black men they're listening to ragtag organizations and they're tainted immediately and they should automatically be denied certain PR bonds or provisions that anyone else should be granted. Now, look, I don't know if that reporter took that quote out of context. They very well may have. I don't know. And I'm a defense lawyer, and I don't believe anybody anymore, quite frankly. I take it at face value. However, that was pretty strong. So we heard out of the 209th, particularly black males are tainted and they should be denied PR bonds because they're not getting advice from their parents and they're listening to ragtag organizations and such. What is y'all's opinion as to the shift or to the discussion and the changes that are happening now in the justice system?
if true, because I want to predicate it off of if McSpadden's words are true, because again, we don't know, we weren't there to witness it, and we don't know if they were taken out of context. However, if they are true,
I mean, he told it to the Chronicle.
I wasn't there for the interview, though. You know, I don't know.
Actually, I got it right here.
He has it.
But if it's actually true what he said, I don't think that the difference between McSpadden and other judges, not all judges obviously, but other judges that are on the bench, is that he said what they think. And I think that that's the biggest difference, that you have one who was accidentally vocal in the wrong time, when most of them have learned to shade their feelings behind their actions and not necessarily emote them out loud. And I think that's the danger that we have, because the assumption is that the bench is fair, that the judiciary is this all-knowing, benevolent human being who's been put there to do God's will, right? But that's simply not the case. You have, these are regular humans that happen to be elected by whatever process and got on the bench. Some of them are awesome. Some of them are not so awesome. But again, it's the human nature of people to have certain biases if you had a bias before you were a judge, pretty sure that bias is not going to magically disappear once you get on that bench and put on that robe. And certain people have learned how to not speak about their biases so they can continue to do what they feel is good work. And others have forgotten, I didn't realize that you were going to say everything that I said on the record. And what we have to do is make sure that you are looking at the history of a person and not necessarily just the history of their work performance when you're electing officials, to basically touch your life every single day. And again, it goes back to the thing I was talking about with empathy. We don't have enough judges, I think, on the bench that are in touch with the regular person or the person who statistically comes into that courtroom every single day. And we need to change it.
Well, I mean, that's a look. I mean, our own Chief Justice of the Supreme Court has never even gotten a traffic ticket. You know? Yeah. I mean, he literally admitted that he'd never been pulled over by a cop. So I'm not sure how you get that, though. I mean, it's very rare that you're going to get the case of somebody who has been able to go to law school, who has actually and be in a position to be on a bench, who's actually experienced that stuff. Because if you've been through the system before you ever get to law school, how are you ever going to get licensed?
Well, I'm not even talking about you've gone through some kind of trial and tribulation, but have you been active in your community?
I know what you're saying. I mean, I know what you're saying, but I mean, in terms of to get people with that have empathy because they've gone through what people who will be standing before them are, I think that's a hard prospect in our profession, just because the bar to get in our profession, I mean,
it's a high bar.
Yeah, I mean, the Board of Law Examiners background that you have to get through just to get a law license. I mean, so I think you're dealing with a profession that on its own shuts a lot of people out from the very beginning.
But before you were a judge, were you actively in your community? Were you volunteering anywhere? Were you being the kind of person that you would want a judge to be? Yeah. And that's the kind of thing that you need to see. It's not before I ever even thought about running for a judgeship, I was at churches educating people on second chance programs, educating them on what it means after you get a deferred and have it dismissed, expunction versus non-disclosure. I was fighting pro bono cases for the gang injunction, that was happening in the third ward area. I put my actions I put my money where my mouth was, and my actions speak for themselves. And I think that you need to vet your people more and say, well, what have you done for the community before you tried to run for the judgeship?
Totally agree.
So I'd like to just address this system about the personal bonds and judges, the positions that they've taken where we find ourselves now today. Because, like I said, I've been practicing law a long, long time now. And pretrial bonds have been around for a long time. Problem is that they weren't utilizing them in an over-the-board situation. The only persons that were getting considered for pretrial bonds were the suburbanites. people from out in Katy, out in Kingwood, down in Clear Lake, the middle class. If they came in and maybe they've got the pretrial bonds. The people in the lower income areas, 3rd Ward, 5th Ward, the East Side, didn't get pretrial bonds. And I think that's what part of that federal judge's ruling was. And so now you've gotten the judges now who've kind of been backed into a corner, and now they're having to explain away why they have not been granting these type of bonds over a period of time. There's one particular judge, and I know him, been knowing him for years. And actually I'm on a pretty good, as far as relationship, I mean, I've known him, I remember when he was a DA. I tried cases against him. And as a judge, I know that he will give you a very fair trial. But he said some things that there's a lot of people have taken odds with. And I just want to just kind of, if I could, address that just for a minute. He said that he had a no bond policy for magistrates for at least a dozen years because he didn't trust the lower level jurists not to make errors. He said, and this is a quote, almost everybody we see here has been tainted in some way before we see them. They're not good risks. He said he was concerned defendants would be released or bond only to be arrested on another offense. Many had casual attitudes about showing up for court. Keep in mind now, at this point, he did not say anything about black or white. He's just talking about alleged offenders generally. Then it comes into the point where he addresses the fact, he says, the young black men, and it's primarily young black men rather than young black women charged with felony offenses, they're not getting good advice from their parents, he said. And this is where it gets ugly. Who do they get advice from? Ragtag organizations like Black Lives Matter, which tell you resist police, which is the worst thing in the world you could tell a young black man. They teach contempt for the police, for the whole justice system. There's going to be contempt for police because it is clear that police, in the past, we haven't seen it within the past month, but in the past that I know of, in the past have killed young black youth. This is documented. This is nothing that we're surmising or speculating. We see this even with the camera phones and the social media. We see this with our eyes, and still these people are being released without any charges. So to say that, I think is just not acceptable. It's not acceptable to me. It's not acceptable to the people in the black community, especially the people of these organizations who are trying their best to bring out what's going on as far as unfairness, injustice to young black people.
Yeah. We got a phone call coming in. Let's jump over and see if it works this time. Hello, thanks for calling Reasonable Doubt.
Hi, good evening. This question's for candidate Renfro. Being that you're running for a criminal court bench, how does your personal experience with the justice system affect your decision making? I think you had a felony indictment for cocaine possession and maybe a deferred adjudication for spousal abuse. And how does that work out in the climate of today's Me Too movement?
Thank you, Patricia, for asking that question.
My name's Alda.
I understand. I take the opportunity to address that because I was a victim of the drug abuse system. I came up at a time when I was a young man when using drugs was a common acceptance in our life. It was unfortunate for me, and it caused me some issues. So I feel as though I have a very unique ability now to respond to that situation. And I take no qualms, I take no offense to anything anyone has to say because I have the ability now. I've been clean and sober for over 12 years, or nearly 12 years, let me say. 11 and a half years, why don't you fact check that while you're at it? And during that course of time when I had that problem, there was an issue with me and my wife, who are currently back together been together for 28 years. You can fact check that too while you're at it. So that is one of the things that as a judge, I can deal with those people who come into my court and have drug problems, who have problems with dealing with relationship problems. I've got that unique ability to deal with that. Take no offense to what you ask, but I ask that when you ask that question, you also know where I've been and where I've come to, because I am the person to deal with that problem. I have no problems with what you ask.
Let me follow up on that. Do you, as a judge, if you had your courtroom, how would you deal with the situation differently, or what would you, how would you deal with that situation? And do you feel that you could deal with it in a better way?
That's where empathy and compassion comes in for me in particular, because I represent those kind of people. I got 2 young ladies right now that got methamphetamine problems, and I see what their parents are going through in dealing with those issues. I can relate to them because I've been there, done that. That's not something I counsel with people. I counsel with people. I deal with people every day. I got a little side business that I deal with where I deal with people who use drugs. And I try to talk to them and help make their lives better. That's one of the things that I want to do, is be an example, because God has changed my life. And he leads and directs me in everything that I do. And so I'm going to be out there. I'm going to change lives. That's one of the reasons why, being a judge, I can do that, judge people. I can be compassionate when compassion is the thing for me to consider. I can be stern when I need to be stern, when I know that there's a situation where a person is just not going to do what's needed to uplift their lives.
You talk about how God has changed your life. How has God changed your life?
I've always grown up as a religious person. My grandfather was a Baptist minister. My mother was a praying mother. I've taken on a spouse who is so religious, and we're in church practically every Sunday. God is in my life every step of the way. And I get on my knees every night and pray to God to direct my lives. I think that's why I've come from where I've come from and come to where I am. And I think you can ask anybody who knows me, that knows where I've been and where I am. They will tell you that Mike Renfro is a better person, and he's a better person because he does have God in his life.
All right, that's all the time we have for tonight. I want to thank our guests, Mike Renfro and Brennen Dunn. Appreciate y'all joining us for the program this evening.
Thanks for having me here.
Ladies and gentlemen, next week is election week for the primaries, March 6th, Tuesday. So get out and vote if you haven't already done it for early voting. But that's all the time we have for this week. We'll be back next week with another episode of Reasonable Doubt. I guess we'll talk about the primaries. Hopefully we'll have the results and see what there is to talk about next week. So,
hey, Judge Fields, I hear you want to come on. Judge Fields on the show.
Bring him on.
Judge Fields.
All right, ladies and gentlemen, we'll see you next week. Good night.